Your appeal will generally be heard in a courtroom similar to this one. You should arrive and be ready for your hearing 15 minutes prior to the time scheduled for commencement. Your case may not be called first, but your presence at the scheduled time is mandatory. It is recommended that you bring your notice of appeal and the reply with you to the hearing. Also, you will need to bring 2 copies, in addition to your own, of any documents you intend to submit to the court. This is required so that the judge and counsel for the respondent can follow your evidence. Before the proceedings commence, locate the court registrar and notify him of your presence. The court registrar will provide instructions, including where to sit, where you will testify, and other information. We encourage you to address any questions you may have to the court registrar before the hearing commences. We suggest that you also inform the court registrar the presence of your witnesses. The court registrar cannot give legal advice or respond to any questions of a legal nature. Your hearing will involve several participants, including the judge, the court registrar, counsel representing the Canada Revenue Agency, and an official for the Canada Revenue Agency. Since hearings before the Tax Court of Canada are accessible to the public, there may be other individuals present in the courtroom. As the appellant, the judge will first ask you to present your case. You will be asked to enter the witness stand and to state your full name and address. You will also be asked to either take an oath on the Bible or give a solemn affirmation. This is your choice. At this point, the judge will usually expect you to present your case. This may involve simply telling the judge the facts and the reasons for your appeal and providing documents, if any, as evidence in support of your explanations. When speaking to the judge, or when he speaks to you, please stand and address the judge as Your Honor. Always face the judge and speak loud and clear. You may also call your witnesses to testify. Remember that you are responsible that your witnesses understand the reason for their attendance, which is to give testimony on matters to which they have personal knowledge, under oath or affirmation, which will support your position. After you have presented your case and called your witnesses, if any, the Department of Justice lawyer will be permitted to cross-examine your witnesses. The judge has no knowledge of your particular case beyond what has been set out in the Notice of Appeal and the reply to the Notice of Appeal, so he may ask questions about your case. Once you are finished, counsel for the respondent will present his position in response to your case. You may cross-examine witnesses called by counsel for the respondent once he has finished questioning them. After all the evidence and facts have been presented, you must present your position as to how the law should be applied to your appeal. Counsel for the respondent will then present his position as to why the appeal should not be allowed. Once both parties have concluded presenting their case, the judge may take a recess. Alternatively, the judge may give his decision orally from the bench or issue a decision at a later date. If you are not in agreement with your decision of the Tax Court of Canada, you have 30 days to appeal that judgment to the Federal Court of Appeal. The key to success when representing oneself is preparation and understanding the process. Reading previous decisions rendered by the Tax Court of Canada related to matters that may be similar to yours may also help you to understand the process and the kind of evidence which may be required to prove your case. For more information, you can browse through the various sections of this website.